All right, welcome into Andrew's podcast. Listen, this is the number one case in South Carolina right now that everybody's talking about, and that being the Alec Murdaugh reversal on the decision. The jury's decision was overturned by the South Carolina State Supreme Court, and now there was a interview done by Alec's attorneys on FITSNews. I want to shout out FITSNews and ask them ahead of time, don't copyright strike me. But I want to do a reaction to this video. I haven't seen it yet, and so like a raw reaction.
So guys, this is a case the world has been watching. It's a decision that we had a sense of where it was going to go. But this is South Carolina. And sometimes when you have the facts on your side and the law on your side, but the politics is not on your side, sometimes decisions get a little haywire. And in this case, you guys had the facts, you had the law, but the politics of this, the Supreme Court reversing these convictions, it's not a popular decision.
Well, let me address that directly. This Supreme Court, I'm not saying ever, but this particular Supreme Court has shown a political independence that's admirable. The rule of law is back. Remember the pay raise, legislative pay raise case that I participated in 6 months ago? They showed they didn't care about the politics. They cared about the Constitution. Again, they applied the federal constitutional rights. And I mean, if you read the decision, they say that's always been their position in Green and several of the other cases. So I think it's clear. And I'll tell you, Jim and I were amazed by the questions that were asked and the comments that were made during oral argument.
Back in February.
It was refreshing. It was encouraging. And again, it shows.
All right, and these are the defense attorneys for Alex Murdaugh.
They're gonna make their calls based on the law, not in the facts, but you're gonna get the application of the law that is uncontested. Remember the law.
And, going into it, Dick and I had to decide how we're going to split the argument. Of course, Dick takes the Becky Hill piece.
God,
which
almighty,
is
that was the tough one. That was the tough one.
Which was not a heavy lift from our perspective.
Golly, gee.
Then I get all the evidentiary issues. And then we're over here at Dick's office about to go to the Supreme Court. And Holly, his 30-year assistant, pulls me aside and says, Jim, Dick and Phil were here last night, and they were saying how glad they aren't you this morning. And so then I go over there, and honestly, I think they're going to rough me up on these evidentiary issues. And it was the other way around, frankly. I mean, they roughed Creighton up, as you rough people up in an oral argument. I mean, it was all very professional. I don't mean to impugn the conduct of the court at all. But one thing that Chief Justice Kittredge said was, the trial judge is supposed to be the gatekeeper of the evidence. And here it looked like the gate was left wide open. And when he said that, I mean, it put a pep in my step, I promise you.
But we're sitting here praising the independence of this court, and rightfully so. I think they resisted the political pressure and the institutional pressure to cover this thing up and just keep this case on the back burner. But one of the justices is going to lose his job for being politically independent. They've literally already kicked him off.
I mean, it doesn't hurt. It didn't hurt Alec Murdaugh having the name that he did. And that didn't hurt at all. And having the money that he had and bringing this thing to justice, not bringing it to justice, but getting it back in front of the Supreme Court as fast as he did.
The court. I mean, we're not in a state where that political independence is rewarded, are we?
Well, look, I'm former state senator. I've been in those discussions, private discussions in the Senate, in joint committees. And I can tell you, I'm not sure that you can make it as simple as Justice Few's vote on the abortion bill in terms of being his downfall. There are a number of factors at play during that, other than that. So I don't even think the court sees his situation as a consequence of rulings.
I disagree. I mean, the fact that Justice Few lost his seat for no other reason than A, maybe they didn't like him, B, his vote on abortion, I mean, is outrageous. I mean, it in my view, once you win, it really should take some misconduct in order for you to not get reelected. And
all right, I am live on Instagram. Please go check me out on Instagram. Welcome to Andrews the Podcast on Instagram. Again, this is you see right in the top right corner. This is an interview done by FITSNews. Go by and check out their FITSNews.com. Go by and check out their FITSNews YouTube page. This is where I'm playing this video from, and this is a video again of Alex Murdaugh's defense attorneys. This is after the Supreme Court has overturned that murder conviction.
I mean, Justice Few he's a smart guy. He's focused. I mean, he was hard on lawyers who showed up in his court and weren't prepared, but, that's the lawyer's fault. That's not the court's fault. And so anyway, I'm not happy with what happened with the Supreme Court race. I don't want to see, I know, Will, you are critical of how our judges are elected in the state. And I don't know the answer to that, but what just happened is, and then having Jay Lucas,
well, I'm not sure it was
teed up to come in.
I think the Lucas thing may have been wired up before. I mean, I think there was an effort in the House to reward Jay Lucas, and that they saw some vulnerability on the part of Few, Justice Few. So it may have been they used that as a way to leverage it in. But if there wasn't somebody like Lucas standing in the wings ready to go from that former Speaker of the House, I'm not sure what would have happened. It's sort of it's a hybrid. Jim and I'm just not sure that absent something like that vote would have gotten him off the Supreme Court.
Looking at the integrity of our system, though, it's incredibly important. And I've often said that this was a case South Carolina had to get right, and we obviously didn't. Now the Supreme Court has come in and remedied that flaw,
yep.
Which, to their credit, I think that's the outcome that the law required. But looking at that distrust of the system, I want to read you two quotes from reporters. One of them, I'm going to use that term loosely, but they occupy different ends of the credibility spectrum. But first is Mandy Matney, who went on CNN last night.
I'm sorry, I don't. Who? That's a person?
A podcaster who got her start on FITSNews, but she said there are two systems.
You started that?
I'm the Frankenstein here on that one. Yes, sir.
Okay, go ahead.
But the quote, I think, has some relevance, and I want to couple it with another one. She said there are two systems of justice in South Carolina, one for people like Alex Murdaugh, the other for the rest of us. Now,
who disagrees with that? Who disagrees with that? Money and privilege. Because, some people say, well, it's because he's white. Well, he allegedly murdered a white woman and a white young man. So do they not get the same white privilege that he deserves? But do you think that there's two systems of justice in South Carolina? Get in the comment section. Let me know. Talk to me.
Quote that I'm joining it with is from Valerie Borline, who I think is a reporter all of us can respect.
Just won the Pulitzer Prize.
She's covered this case better than anybody, including us. But she said that for decades, the law didn't apply to Alex Murdaugh in ways that benefited him. Maybe just once it should be that the law didn't apply to him in a way that hurt him. What do you guys think of that perception?
I don't want to give credit to Mandy Matney, but truthfully, not all defendants get the shake that Alex Murdaugh gets. Not all defendants can hire.
That's it,
right.
There you go.
And we wouldn't be sitting here if we weren't good lawyers. And so, and we don't give it away. I'm not going to disagree that if you cannot afford, legal defense in a criminal case,
that is just the reality of the situation. You could be black, white, green. If you got the money to hire these type of attorneys, you can make some stuff happen that just not going to happen for the average Joe that doesn't have the financial resources that an Alec Murdaugh has. And that's just point blank for anybody.
That are your chances not as good as Alec Murdaugh's was? I'm not going to argue with that, but it's not two systems of justice, in my opinion. And then as to what Valerie said, I mean, Alec did benefit from, how Hampton County and that whole district, ran for
Operates. I like this. Let's go.
years and years and years. His whole firm did, and then, as we got ready for trial, we're looking at Colleton County.
Alec was able to give them some insight that he had because, again, he benefited from the system. You heard the man just say that. Alec benefited from that system down there that his family was the head of for a long time. So, no, I mean, you got to be a fool to think that you'd get the same anybody that's not named one of these people or their direct family members to think that you get anything different. And no, it's not fair. So you go, oh, it's not fair. Okay, it's not fair, but it is what it is.
And we think that Alec has this reservoir of goodwill in that community, and that's why we didn't push to get it out of there. I read a quote article and quoted Joe McCullough yesterday. He said everybody in the community had the feeling going in that this case was going to be fixed, but no one thought it was going to be fixed against Alec Murdaugh. And so, that's kind of what happened.
Well, and let me say this about Tucson. South Carolina is no worse than anywhere else in this country. If you have resources, if you have
money,
some influence,
connections,
you are going to be able to hire lawyers, not go with the 26-year-old public defender who just got.
There you go. Let's go, Harpulio.
Out of law school last year. In some states, they have a great, well-funded public defender system. To be frank with you, we don't. And so if you can't afford to spend the money on somebody with experience, somebody who's going to charge you a lot of money, you are at a disadvantage. Now, also, I would say, what Jim just said, which is, and what Joe McCullough said, which is, we thought, based on talking to Alec's family and members of his firm, everybody loves the Murdaughs. Okay.
When then everybody knew Alec loved his family and knew that Alec could not have done this to his wife and son. I mean, that, and we probably didn't analyze that information critically enough. But
well, we're talking about Colleton County. Let me go ahead and ask you, the Attorney General of South Carolina, who has the current decision-making power over this case, whether to retry, said that this case will be retried within the calendar year in Colleton County. Do you think he's...
Okay, so seriously, this guy's running for governor. And
the front runner for governor.
Alan Wilson, he's talking about.
Whatever. That's comment on the state. But two things. One, I would note that this is the only criminal case he's appeared in as Attorney General and handled a witness in 20 years. And apparently he's not listening to Creighton, because that's not what Creighton Waters said to the press yesterday. We'll see is what he said. He wasn't being adamant about it. This is just political hyperbole on the part of Alan Wilson without regard for the facts, for the law. I guess he's trying to get a little bump in there before the voting in 3 weeks. So there ain't no way this thing's being tried this year. And we think that a change of venue motion will be granted. What I'd like them to do is sit down with us, as soon as we get a judge, sit down with us and talk about A, moving it somewhere else, and B, where. We ought to be able to agree on that.
I just figured out how we can get paid, Dick.
How's that?
Is it Cashy has a prediction market? If we could bet on it, that this case would not be tried before the end of the year,
Yeah,
I think we can make a lot of money.
We get a lot of money.
I'm taking that bet too. I'm rolling with these two fellas right here, because what Dick Harpulio said was very, very key. Alan Wilson just got up there and tried to, secure some more votes, get another bump before the June primary comes in. And so if they get that on Cauchy, I'm entering a bet on that.
I wanted to read you guys. These are some direct quotes from folks in Colleton County responding to this news. One of them said, "People around here will convict him again anyways because we're tired of him. Sir, go away." Another, and this is the one that really hits home, "Bring his ass back here. This time we'll fry him." So
Well,
I don't know if you guys can get a fair shake in Colleton County.
we pretty well determined based on 6 weeks there, we're not going to get a fair shake. And of course, you got the clerk of court fixing the jury or trying to fix the jury. It's unclear as to whether it was really one of the jurors said she was influenced by it. The rest of them did not, but it doesn't matter.
I mean, after all of what happened, there's no way you can retry it in Colleton County with the clerk pleading guilty. The clerk's son is under indictment, the former clerk, and then 6 weeks of trial there. I mean, that's just not going to happen.
Let's talk about her conduct for a minute. She pled guilty to misconduct. She pled guilty to perjury, but there was this whole production, seemed almost stage managed, between the prosecutor, the judge, and her own attorney about, well, if this had been jury tampering, things would be different. Well, we just had a Supreme Court unanimous, monolithic, emphatic decision saying, yes, it was jury tampering.
Well, no, that's not what they said. Well, they did, but you got to look at it in this way. The jury tampering statute encompasses two things: jury tampering and attempted jury tampering. So Toll's factual finding was that she attempted to do that, but did not
see. And it's like he was saying earlier. That's what good lawyers do. They find these things, these threads, these loose threads, and they pull on them. But you got to have some money for somebody to do the pulling.
Influence a juror. The Supreme Court said for us to get a new trial, we don't have to prove that she did influence a juror. So you don't have that. I mean, it'd be as if you walked into a store with a gun, walked up to the counter and said, "Give me your money." The clerk says, "Go to hell, get out of here." And you leave. What's the crime you're guilty of? Attempted armed robbery. Okay? This statute, the jury tampering statute, says tamper with or attempt to tamper with. So
by her comments.
Now, and why is Alan Wilson not prosecuted? Why did he send that to a solicitor, one of his best friends? Why isn't he standing up and doing it himself? You could have taken it. It's public corruption. You could have taken it to the statewide grand jury. You could have investigated it, put people under oath, all those bailiffs and folks that were just interviewed by a sweat agent, an agency that's vested in there not being a new trial. I mean, it's
abundantly clear there was a verdict protection racket going on here. There's no doubt about that. Let me ask about Becky Hill, though. We're talking about her criminal conduct, to which she's already pled guilty.
Not as to jury tampering.
Correct. What about civil liability? Is she on the hook civilly?
Could be.
Is that something you guys would pursue?
We're thinking about it.
Yeah, that's all we want to say today.
Because there's a lot of unanswered questions. We know the jury was tampered with, but there are other allegations made by, for example, the egg lady, Myra Crosby, who was kicked off this jury at the 11th hour, a decision that was decisive in the original verdicts. Had she stayed on that jury, I don't think we would have had guilty verdicts. What about the allegations she's made that this thing was rigged? Do you find credibility?
It's going to be hard for them to get this trial, get this thing retried. I think these guys, they plan to run the clock out.
Those?
Well, yeah, I do. But I don't have any evidence to support it. But I'll tell you this. Should I tell him this?
No, not today.
Okay. No, not that. This.
The two of you do.
During the trial.
I know what you're going to say. Yeah.
Alec kept a journal. Okay. And in that journal, he has written, because Myra would come in and she would smile friendly at our table. And Alec has in his journal, I wish she wouldn't do that. They're going to find a way to get her off the jury.
Alec Murdaugh put that in his journal.
Abso-fucking-lutely.
Have we ever told anybody that?
I don't know that we have.
I don't think we have.
Well, they did.
Yeah. I mean,
Well, we know now.
we were all fearful that, she was showing friendly gestures toward us, and everybody in the courtroom saw it. And then, we're getting toward the end of the case, and all of a sudden they come up and say, we want to see the lawyers. We got this Facebook page. And the Facebook page wasn't even from her ex-husband. It was some other guy we tracked down in Georgia who was one of, 6 million people in Georgia who had not heard of the Murdaugh case.
Never heard of it.
Probably the only one who had not heard of it.
It took multiple attempts to get her off.
Yeah.
Yes. And and look, we're sitting there. Again, we think Becky is straight. We don't see her, we don't know she's talking to the jurors. We don't know she's told people that she needs a guilty verdict to sell more books. We don't know all that.
And that was a part of it. This Becky Hill that they're talking about, the former clerk of court down in Collin County. One of the things that came out in the lead up to the overturning of the conviction was the fact that she was in deals with these movie companies trying to sell profit off of this case, and it was essential that she get a guilty verdict. It was essential, not that she get it, but it was essential that Alec Murdaugh was found guilty in order for her to capitalize fully off of the information that she had being privy to as the clerk of court.
And by the way, Jim and I were talking about this. We've never had a clerk of court that we didn't totally trust. Totally. Mm-hmm. This is a despicable act, and she's not been punished for it.
Who could have engineered Myra Crosby's ouster from that jury? Who could have pulled the strings to get her kicked off?
Certainly
there are plenty of people.
Plenty of people. And hopefully one day we'll get to the bottom of that.
Could a civil action against Becky Hill be a way to get to the bottom of that?
That's one possible way.
And people are looking at that, and people are, of who could be involved, and I'm not going to name names here today, but you read the stuff online that I read the stuff online, and you're digging through the discovery and the Parker case, the names of witnesses that come up, and how there's, if you start drawing lines, it's very curious, the names of the people who are implicated in that.
Now,
that's as far as I'll go with it.
As an agent of the state, Becky Hill's misconduct, does that open the door to a potential double jeopardy motion? Because if it were prosecutorial misconduct,
it opens the door, and Phil Barber, that was part of the team, is looking at that, and we're doing some, based on the decision Wednesday, we're looking at some analysis on that. But those are difficult allegations to win, and if it delays our ability to get going on discovery on the criminal side, I'm not sure that we'd go that way. And again, that's Alec's decision, not ours. We're hoping to see him in person in the next week or two.
We'll get his thoughts on strategy. He's still a part of the strategic decisions?
Always will be. He's the client.
Yeah, he's the client.
What about a motion on these warrants? Because everyone, after watching the trial, now knows that there were untruths told to secure the murder affidavits, the probable.
All right, y'all, make sure y'all go check out FITSNews over on YouTube. I'm sure they got a Facebook page, FITSNews.com. That's where I'm playing this video from.
Cause affidavits. Will you challenge those warrants and try to make SLED re-indict him?
It's not the warrants, it's the indictment. And, that's a really good point. We haven't, that's an almost impossible test. And here in South Carolina, we do not transcribe. It's not recorded, the testimony before a grand jury. In federal court, it is. And so you can see what was said to the grand jurors. The only way we were able to bring out that David Owen gave false testimony to the grand jury is they produced his notes of his testimony that he was going to go through. And then I had him on the stand and I asked him, didn't you tell the grand jury? And you may remember from the trial, Johnny Meadows gets up and says, there's no transcript of what was said in the grand jury. And he had no idea that because he came on the team late, that they had produced his notes. And so that's how we had that. We do have it. And he did mislead the grand jury about some critical facts. But,
I don't know what that gets you except this.
Another indictment.
Right, another indictment. So what's important about that? It's important he has admitted that he lied under oath, 1. 2, since this trial, a case, as you know, was dismissed because he allegedly hid evidence. So, I mean, those
are the Colucci case.
Pardon me?
The Colucci
Absolutely. Case. So we'll begin now to look in detail at that and see if that's something that he can be impeached on when he testifies.
This is Alec Murdaugh's lawyer, his defense attorneys, Dick Harputlio, and I keep forgetting the other gentleman's name, but this is the defense attorney for Alec Murdaugh, the world-famous case out of Hampton County, South Carolina. This past Wednesday, South Carolina State Supreme Court overturned the conviction, and so his lawyers are here now talking.
So liar, liar, pants on fire.
But I got to turn that on you. Your client testified in his own defense at the first trial and was caught lying on the stand. Creighton Waters boxed him in and he told multiple.
Here's the difference. The difference is whatever he testified to in the first trial is prohibited to be used in the second trial by statute. That's number one. Number two, that will be a factor that will put, when we say game day decision, that will be a factor in determining whether he decides to testify or not. But they can't say a word about him lying in the first trial, period. And
would you advise him to take the stand again?
It's too early to tell.
Yeah, remind me what he was caught lying about in the first trial.
Well, let's talk about all the things he's been caught lying about. He first said he was never near the kennels. Then
No, Will. I'm talking about when he put his hand on the Bible, got on the stand, and testified that I lied about being down in the kennel. I lied to all these people about that. But during his trial testimony, I don't remember him being caught in a lie. I remember him admitting to a lot of the lies that he had made, a lot of lies to his clients. But
and that's a big difference.
I mean, and Creighton did a masterful job.
Educated, but I don't know that Creighton Waters got Alec, caught him in a lie from the witness stand.
Okay.
And he's right. He did admit to lying, but caught him in a lie.
Fair enough. But in the event that he is in that situation again, it was very clear from your body language and the way that you introduced his appearance on the stand. The defendant wishes. You didn't say you were calling him, and it felt like the two of you had counseled him not to.
We're going to work on Jim's body language.
Fair enough.
I'm wearing a bow tie next time.
Yeah, that'll make all the difference.
Yeah.
There were some very pointed parts of that Supreme Court decision that came down. Obviously, Becky Hill's misconduct was excoriated. Gene Toll's analysis of the law was rebuked. But they went pretty easy. It was a gentle chiding for Clifton Newman, the trial judge. However, within that gentle chiding, there's a lot of financial crime testimony that it seems that the state will not be able to use in a second trial. How does that narrow their path?
Well, Jim argued that in front of the Supreme Court, so I'll defer to him.
Well, let me first talk about a trial judge and the position they're in when the state seeks to overreach. If the trial judge excludes the evidence and turns out to be wrong, there's no remedy to the state because the state cannot appeal. If a defendant is acquitted, it's double jeopardy. But if the trial judge erroneously admits the evidence, then it can be reviewed on appeal and determine whether it's reversible. So as a trial judge, the default position is to let it in. And so really, I mean, I put the blame, and I told Creighton during the trial, you're going too far. You're asking for too much. You're risking a reversal. Why are y'all
told him that during
the trial?
Yeah, absolutely.
Absolutely. As lawyer to lawyer, said, you're asking for too much, Creighton.
What did he say?
Well, we think it's appropriate, and blah, blah. And same bullshit he told the Supreme Court that they, rejected. And so they did go too far.
Do you think he made that decision in a vacuum, or do you think that was coming from on high from the AG?
I mean, it's just, I don't know who made the decision, but as a prosecutor in a case like this, when the evidence was so weak he did the murders, I mean, they're looking for everything they can, and the world is watching. And you'll remember, maybe not, it wasn't until after Judge Newman issued his ruling on the financial crimes did Alan Wilson show his face in the courtroom. After he entered that order, written order, the next day Alan Wilson shows up, and he didn't leave the table the whole time. So you tell me.
And let me say this to you. Both of us are former prosecutors. I was a state prosecutor. Jim was a federal prosecutor. When you're prosecuting a case, there's all kinds of stuff you can probably reason with the judge and get him to put in that has a more than 50-50 chance of being the grounds of reversible error. A good prosecutor doesn't throw it up against the wall and see if it sticks. They say, I mean, I was faced as a state prosecutor because it was a little more loosey-goosey in state court with introducing stuff that I knew, hearsay statements or third-party statements, co-defendant statements, or evidence that clearly, we can, both of us remember in state court, judges, after they initially allow it in, or the objection comes after we hear what it is, the defense attorney, or we, or if I was prosecuting, the defense attorney make a motion for a mistrial. The judge rules, yeah, you can't do that. I'll give a curative instruction to the jury to disregard that testimony. And of course, we always argued, or it was argued against us, you can't unring the bell. And in 99 times out of 100, the judge didn't declare a mistrial because other evidence came in that the court could say overwhelming guilt or whatever. But in this instance, let's look at the timeline. They had Alex's shirt they took from him that night. They had tested, and there was blood spatter on it. I mean, that was a critical.
You reported that. You broke that story.
You broke that story. Blood spatter on his shirt.
I think that was the Frankenstein.
Well, one of your creations.
It was our outlet that published that. Yes.
And so for almost a year and a half, that was the narrative. And I think they said, we're going to kill him with this. Matter of fact, they'd hired an expert in Oklahoma, renowned blood spatter expert.
Works in his garage.
Right, but he was renowned, to be an independent witness on the blood spatter, okay? And that was just a few months before the trial, right?
Yeah, I mean it was
late. So they hired an expert, and we saw a draft of that expert's report where he was saying it wasn't blood spatter. We later found out not only was it not blood spatter, it was not human blood.
So what convicted him in the court of public opinion,
right,
was bullshit, according to your
legal term, bullshit. Yes, it was not true, and yet they pumped it out there as hard as they could, which in and of itself, as a prosecutor or law enforcement, you don't go leak stuff. And who told you?
This is when they talk about dot the I and cross the T. This is when you got to dot your I and cross your T's. And have competent lawyers on your side. Because the burden of proof is with the state, and they got to do it right.
Wasn't my tip. Well, Frankenstein's situation, remember?
Oh, I forgot. But
so one other piece to that is we get discovery from the AG's office. And so we have all the information. But, you know, we took it one step further and we sent a subpoena to SLED and served it on their general counsel. SLED did a separate production. And it was in that second production.
That's correct.
That there was an analysis as to whether that was blood or not. And the report of the forensic lab says it's not blood on the shirt. And that was not provided to the expert out in Oklahoma. That was not, and David Owen claims he never saw that. But I mean, there it was, plain as day in their system. It was produced to us, and we attached that to our motion that we filed over Thanksgiving. And you know,
I don't think he told Creighton.
No, they didn't know it.
They didn't know it.
They didn't know it. And so, I mean, was that hidden intentionally?
Well, and so there they are, 60 days out. What are they going to do? Throw everything but the kitchen sink without regard for whether it would result in a reversal or not.
That's when the financial crimes became necessary, is what you're saying.
Absolutely.
Oh, well, they were always.
They were going to use it, but I don't think they were going to go.
Well, full bore. And then they switched to, oh, Mr. Clean, you know, he changed clothes. And where are his clothes? Which was such, I mean, you know, I don't know how we deal with that, how well we dealt with it during the last trial, because I mean, this whole switcheroo to, oh, he changed clothes, where are his clothes? I mean, they never asked for his clothes because they spent their whole investigation thinking he had blood on that's what he was wearing at the time of the murders. And then all of a sudden, where are his clothes?
You know, one thing they did do very, very well was swab every shower, every sink, anywhere water could have been used to wash blood off, and found no blood in the house that night. So, again, there's no fingerprint. They didn't try to take fingerprints at the feet. They didn't try to get DNA. They didn't try to save tire tracks that were clearly there. They did no investigation when they decided that night it was him.
So these guys are floating theories out there right now. This is a powerful interview. I don't know if it's gonna where the view count is. It was right at 1,000 when I decided to share it, but it is very interesting in what the lawyers are setting up here. Basically floating out, you know, theories because there is a lot of validity to what is being said right here.
termites don't need an invitation. In South Carolina, the pressure is real. Warm weather, moisture, crawl spaces, wood-to-ground contact. That's the perfect setup for termite activity. By the time you see the damage, they may have been there for months or years. Softwood, mud tubes, hollow spots, hidden damage. Don't wait until the repair bill tells the story. Schedule a termite inspection today. Palmetto Pest Control, LLC. Veteran-owned, local, certified. Protect the structure. Protect the investment. Visit www.bedbugheatkill.com.